Welcome to the next instalment in Contract Conversations. Today we're going to look at something a little bit different from the strict legal issues that we usually look at, and try and look at some strategies which you can use to try and avoid disputes. Sometimes disputes are unavoidable, and so what we'll do is we'll also look at what steps you can take to try and put yourselves in the best position possible if that does occur. Before we begin, and just by way of introduction, my name is Mark Davison. I'm the head of international arbitration here in our London office, and I'm joined today by Doug McDonald.
Hi everyone, I'm Doug McDonald. I'm a partner in our commercial disputes team, and with a focus mainly on tech and life science clients.
Perfect. Just a bit of housekeeping before we start. There is a Q&A function on the screen, so please do feel free to ask questions. I think we have about 150 today on the call, so what we'll do is we'll try and answer as many of the questions at the end as possible. And if we don't get to them, then what we'll do is we'll follow up as we usually do and try and answer those directly. So the mantra for today is going to be to start early, be proactive and be prepared. And so with the mantra of starting early, avoiding contract disputes starts even before you've entered into a contract with your counterparty. So in respect to the first point of the slide there on the screen, in order to try and avoid disputes, we think there's actually a step which you can take before you've even entered into a contract with a counterparty by performing due diligence on the counterparty. And one way of that could be to check credit reports to see whether there's any evidence of failure to honour debts previously, and also to check the court file as well to see whether they've been involved in any disputes. And that might give you an idea as to sort of how litigious they may be, or as to their ability to perform contracts in other contracts that they've had with other counterparties as well. In respect to the second point there on the screen, about contract drafting, I appreciate a lot of what I'll say here is going to be fairly obvious, but we do appreciate that obviously within an in-house legal function that whilst you get involved in contract drafting, actually that a lot of that might be put on the commercial teams that actually will deliver the project going forward. And so when you're drafting contracts, one important thing to always think about is what issues may become contentious. And if you think about those carefully before you've entered into the contract, you can try and ensure that there's no ambiguity about any particular clauses, fully appreciating, clarify what it is that the objectives of what the parties are to perform. In respect of performance monitoring, which is the second point there on the slide, this is common in sort of medium to long-term projects, especially in the construction and tech world. But what we see is that almost as a dispute avoidance mechanism, what they have is regular monitoring requirements. So that might be either reporting or regular meetings. And what we tend to find is that they actually flag up disputes before they often emerge, and can actually help try and stamp out a dispute before it actually becomes an issue later on, because it's only discovered later on. Again, within flexibility there within the contracts, again, obviously we've seen it in light of the COVID pandemic in respect to reliance on force majeure clause and materials adverse change clauses. But given that we're still not out of the woods yet with coronavirus, and we've still got the impact of Brexit to come, if you are drafting contracts at the moment, you might just want to ensure that there are specific sort of flexibility within those contracts if there are some unexpected consequences which occur going forward. I mean, even if you can sort of foresee them at the moment, you might just want to ensure that there is some flexibility there going forward. In respect of tiered dispute resolution clauses, obviously, the most common type of dispute resolution clause that we see in agreements are, I'll just refer the dispute straight to litigation or to arbitration. But actually, you don't necessarily have to have that. And what you could have is what we call tiered dispute resolution clauses, which require parties to take a particular step before they go forward with the litigation or the arbitration, such as having a meeting of management with X amount of days. In certain circumstances, we've seen parties having to go through a mediation process before they can embark on litigation, but we don't necessarily recommend that in all types of commercial agreements. But it can be an effective way to try and resolve a dispute without actually having to incur the expense of going through the litigation or arbitration process. And then the final point on the screen there, I appreciate this is very cheesy, but it's one thing which I always sort of advise when speaking to clients, either about the contract drafting stage or even before embarking on litigation. But it's this enforcement. And it's just any time before you're about to enter into a contract or embark on any litigation, just to think about how is it that I'm going to be able to enforce any judgment that I've got. For example, is your counterparty based overseas where it may be difficult to enforce the judgment, and alternatively, is your counterparty insolvent or struggling for cash at the moment? And then just very quickly, in respect to contract management, I appreciate for many of you in large organizations, it's just not possible for you to be able to review every contract regularly. But what you may want to do is, especially for those where you have commercial teams or operations teams which are running the contracts, is you may want to set up an audit type system where, say, every 6 months or so, you speak to them about the contract, get them to review the contract just to make sure that the key obligations are being complied with. And that should hopefully sort of illuminate any potential issues before they occur. And then just in respect to the final point there about record keeping, again, I would encourage your commercial and operations teams to try and keep a clear record of what it is that they're doing through a particular contract or project. And especially if our decisions are being made, that there's a clear record of that. Doug and I see time and time again that people's memories change over time. And so courts generally prefer what's said in a contemporaneous note that was taken at the time, especially if that conflicts with what a witness may say in 3 years' time when it gets to court. I'll pass on to Doug now about avoiding contract disputes, about being proactive during the contract.
Great, thank you, Mark. So if a dispute is on the horizon, you should review the relevant contracts and the key documents, such as change control notices, the amendments, variations, as well as any key correspondence. And for example, if there are project management meetings, then the minutes from those meetings. The starting point, whilst obvious, is to establish the contractual position and what you are actually required to do. And as Mark has mentioned, if you are experiencing difficulties, do any of the terms of the contract excuse performance? And if so, what do they actually say? And what do you have to do to enforce them or rely upon them? One thing that I see time and time and again is often that one party is not delivered in some way, and it is an ongoing issue. The general unhappiness continues into the point at which a director of the other party will then tell normally an in-house lawyer or a contracts manager that they have to go legal, whatever that might mean. Especially at that point, and I appreciate that in large organizations, the in-house legal team may not be aware of certain contracts or disputes until that particular point, but it is very important at this point to commit sufficient time to objectively consider the legal position. At one end of the scale, it might appear to be a simple non-performance, such as non-delivery of a product, but does that actually give you the right to go legal and terminate? Whilst common sense might appear to suggest that you could, is there an obligation, for example, in the contract where you have to provide the other party with an opportunity to remedy that breach? Or, and again, we see this often, is it an old and ambiguous contract where it's not clear what you can and can't do? At the other end of the spectrum, it may be much more complicated. For example, an outsourced software contract where it will not be clear whether the required functionality has been delivered according to the contract. Again, it is so important to commit time and objectively challenge your business colleagues at this stage. For example, your colleagues may insist that the software platform does not do what they were promised it would do because they were expecting a plug-and-play system. But what does the contract actually require the provider to deliver? Again, can your technical colleague point to the contract clause or the specification that has not been delivered? Have there been so many formal and informal variations to the contract that the contract actually no longer reflects the reality of the situation? Rather than launching into full-blown termination letter, unless you are confident in your position, you or external lawyers that you instruct should objectively challenge your business colleagues against the backdrop of the actual contract. Whilst this may sound obvious, it may also sound time-consuming and slightly awkward in terms of challenging someone internally. It is a lot less painful than full-blown litigation or even just a protracted commercial dispute. So involving us early is also far more cost-effective. We do appreciate that there is a balance between being an agile in-house lawyer or commercial manager, providing legal and commercial advice to the entire organization, against the need to avoid formal disputes if possible, not to mention that the valuable commodity of time might not be available. As a practical tip, and if you don't already, perhaps you should have a template email, for example, that you can send back to your colleague that will ask for the required information at the outset, not just the contract, but also the key correspondence and minutes of project meetings where the relationship may have been varied informally or formally. That template email could also include a few initial comments in terms of what your colleagues should and shouldn't do. For example, preserving documents and being mindful of not communicating with the other party, or if they are going to communicate, then how they do it. It is also important to understand the dispute cycle. Often, commercial disputes are left unresolved until it is too late. If a dispute is on the horizon, reach out to your counterparty early to try and reach a commercial solution or compromise. It might feel that a resolution is not possible, but it is often easier to resolve a dispute when there's still some relationship existing or before the parties have been left to stew for too long. You should consider whether to make approaches on a without prejudice basis, and this should be done very much in parallel to the review of the legal position I've just mentioned. A key tip here is to educate your colleagues, your internal colleagues in your internal business as to the actual meaning of the term without prejudice. And make sure that they know that it does not mean you can put it on every email and then say whatever you want. People often use it in the same way as no offense but, or with respect but, and then say whatever they want, which can compromise your legal position when a dispute arises. In terms of contract notices and limitation, consider if your contracts require you to serve any contractual notices and whether these need to be served within a particular time limit, which may prevent you from taking further steps on if you do not serve them. If there is a requirement, a court would expect you to comply with it. And I'll pass back to Mark.
Thanks, Doug. So we are now going to just quickly look at some tips of what you should do if it looks like a dispute is unavoidable, even though you followed through the tips that we've given before about how to try and actually avoid the dispute. And the purpose of this is really just to make sure that you're in the best position possible to go forward and that you're not on the back foot. So again, as I covered before about enforcement, before embarking on any litigation, please do consider how it is that you're going to be able to enforce any judgment. I've also had that in the context of clients as well with counterclaims where they've been defending proceedings and they feel that they have a legitimate counterclaim. Again, to look at the question, is it worth spending the time to embark on the counterclaim? Because even if the defence succeeds, you might be able to sort of offset that against the original claim, but you're never actually going to be able to recover the value of the counterclaim if your defence succeeds. In respect of witnesses, once your commercial colleagues have come to you about an issue, please do consider at the outset what witnesses it is that you're going to need. Cases live and die on witness evidence. And especially if your business is about to go through a redundancy process or you're aware that a key employee involved in the issue, which has become contentious, is about to leave, think about what it is that you might be able to do to try and keep those witnesses within the business, because there's no property in a witness. So once they've left the business, it can be often hard to try and get them to come back and give you the witness evidence that you need for your case. In respect to documents, again, once it's obvious that an issue is about to become contentious, you should take steps with your IT department just to make sure that relevant documents are kept. Speak to those that are involved with the project as well to make sure that they know that they shouldn't be deleting any hard copy or electronic documents. And as part of that, actually, you might want to just give them a document hold notice just so that it's clear to them what it is and what it's not, what they cannot do. It's a requirement under the CPR, so the Civil Procedure Rules of the Courts of England and Wales, that parties who know that they're about to be involved in litigation have to take steps to preserve documents anyway. In respect of insurance, this sometimes is often missed, but you might just want to consider with your brokers whether actually any policies you hold actually might cover the claims which are being made. It's important to do that early because certain policies require that notifications are made to insurers within a set period of time. But please don't lose sight of the fact that there may be a policy out there which helps you. And again, just following on from Doug's point about seeking specialist advice, again, we appreciate it depends on the commercial value of the dispute, but discussing with experts, with litigators, what it is that your rights are and what weaknesses and options you have with your case early on can often try and help save you money in the long term, rather than embarking in sort of protracted correspondence with the other side where it is that you might actually give up something which is potentially harmful for your case. The point there about mitigation, parties often lose sight of this, but if you have a valid claim against a counterparty, certainly as a matter of English law, you are required to try and mitigate your losses. So please don't lose sight of that. So if you have suffered a loss, just don't throw the towel in and say that I'm not going to take any steps further in that project. You have a duty to mitigate losses. So in certain circumstances, that can require you to spend a minimal amount of investment as well, if that's to try and mitigate greater losses going forward later on. And the final point there about litigation funding, we did a contract conversations on this a couple of months ago. So what I'll do is I'll put a link into the follow-up to this about litigation funding. But again, appreciate that litigation, it can be expensive. But there are alternative providers out there that might be able to provide you with solutions to try and remove some of the cost of funding the litigation, or at least move that off balance sheet for you, which might be of interest to you and especially your finance teams as well. Doug's going to very briefly look at some of the don'ts if disputes are unavoidable.
Thank you. So you've heard what to do from Mark. And as Mark mentioned, I'm going to now summarize some key what not to do's. Don't terminate without considering the legal basis first, without seeking external advice if required. Incorrect or unlawful terminations are a very rich source of work for litigation lawyers, as people so often get it wrong. As you will probably be aware, if you unlawfully terminate a contract, your counterparty may accept your repudiatory breach and then sue you for damages. Generally, you cannot take back a termination. You also cannot reignite a contract that has been terminated. So it's even more important to get it right. Don't just pursue legal remedies. You should also look at commercial solutions in tandem, as I mentioned earlier. This may lead to the best result, but always do them in parallel. You should try to avoid the situation where you are convinced that there will be a commercial solution, so you ignore the legal position and forget to protect yourself. So they must be done in parallel. From my experience, certain corporate providers or contracting parties are very good at making it look like they want to do a commercial deal, when in fact they are laying a retrospective paper trail to assist in a future claim, often with their lawyers inputting in the background into those communications and letters involving wording such as, "We want to resolve it, but we are incredibly disappointed by your failure to follow the terms of the contract." Don't just assume that you can rely upon force majeure type clauses for excusing performance under the contract. Check whether your force majeure clause actually covers the extent of the event you are facing, and whether your clause requires you to take steps to mitigate the consequences. As you can imagine, force majeure is a clause that lawyers of today have probably not given much thought to until March last year. but now know it very well. It is a creature of contract, so it all depends upon the exact wording and not general principles. If you are entering into new contracts and you want COVID to be covered, as mentioned earlier, you need to make sure that you expressly refer to it. Don't waive privilege, whether that be legal advice privilege, litigation privilege, or another form. Privilege is a topic that we could talk about for a week non-stop, but just to flag, take care when communicating issues internally. Litigation privilege only applies once a dispute is reasonably in contemplation. Emails, notes of meetings, and discussions with those involved in the project may be liable to disclosure, unless it can be shown that dispute was reasonably in contemplation at the time. As a practical tip, ensure that your colleagues do not undertake an early lessons learned exercise where they outline in writing everything that they have done wrong, unless it is actually covered by privilege. Again, we see this often. If you are an in-house lawyer, I appreciate you are often moving between providing legal advice and providing general commercial input to the business. You need to be aware of when your communications are actually privileged and when they are not. It really is a minefield, so please do get in touch if you have any questions about privilege. But by way of example, be mindful that even a partial disclosure of information may be deemed to have waived privilege in a document or wider group of material more generally. It is certainly worth having privilege in mind from the very outset and taking practical steps so as to increase the chances of something being privileged. In terms of legal advice privilege, again, it is a topic in its own right, but just copying in the in-house lawyer is unlikely to be sufficient. It must be for the purposes of obtaining or giving legal advice. And finally, don't ignore the pre-action protocols in the civil procedure. There are certain requirements under these, and you have to take certain key steps. Do not ignore them. Whilst you may not be in a position or at a stage whereby you have to follow every step, it is certainly worth being familiar with them so as to avoid having to start the process again when you instruct external lawyers. I'm going to pass back to Mark now to tell you why you should not ignore the government's guidance on reasonable contractual behaviour from May and June of last year.
Yeah, so very quickly, we covered this in another contract conversations on reasonable endeavours and good faith. And so what we'll do is we'll follow up to a link to that webinar as well, and just give you the minute of where we talked about this. But this was the UK government guidance, which was issued last May and June, which basically requested and encouraged contractual parties to act responsibly and fairly in the national interest in performing and enforcing their contracts. So basically what the government was asking was, in light of the COVID pandemic, was for parties to act in good faith and to think more carefully more than ever before suing each other. Whilst that guidance wasn't binding on parties, we sort of flagged the issue that it may become relevant when it comes to elements of judges exercising their discretion, so a particular point on the awarding of costs. But actually there was quite an interesting article a couple of weeks ago in the Law Gazette which suggested that actually parties may have been following this guidance more than we actually expected, certainly within the legal community. But again, I'll follow up with a link to that part of that presentation in the follow-up after this, given the time remaining.
Is it just worth mentioning in terms of sort of Mills and Reeve, we have over 150 litigation lawyers here, and we are here to help, not just in terms of litigation, but also to advise on general commercial risk management and how to avoid disputes within your particular sector, which includes us being very happy for you to bounce questions and issues off us, especially before they've turned into a dispute. And very briefly, just to mention, we also offer what we call a defence counselling session, which in normal times would be myself or Mark or one of our team spending an hour over coffee talking about the above on a one-to-one basis or with your wider legal or commercial team, and can be tailored depending upon your organisation and the risk areas. So please do get in touch if that would be of interest to you.
I'll make sure to include that in the follow-up as well. Just very quickly, just conscious of time, just some of the questions that we've got here. So one of the questions is when is without prejudice useful? I think, again, I think that question was asked before Doug got on to the point about ensuring that you don't waive anything in the context of without prejudice communications. But without prejudice communications, they can be useful in trying to settle a dispute. I think what you need to be careful of, though, is ensuring that actually it is a genuine attempt to try and settle the dispute. You're not just having a sort of general conversation with sort of allegations. The predominant purpose of the WP correspondence has to be that the parties are trying to settle the dispute. So, I mean, I think that even when you're involved in protracted litigation, there can often be a side set of correspondence of WP whilst parties are trying to settle it. So I think it's always useful throughout a process if there is a potential avenue there to try and settle a dispute early. Doug, I don't know whether you have anything to add on that.
Just to add, it's there to allow you to try and resolve it or to settle it, but without you then having to show the court that communication. So you don't need to worry about compromising your position if it is a genuine without prejudice communication.
Yes. And then there's a question here, which I'll just pick up about, dispute resolution clause in the context. So what dispute resolution clauses should you be using at the moment in the context of when you're entering contracts with European counterparties? So I appreciate this question has probably been raised in light of the fact that we've raised this in previous webinars previously, but the Brussels recast regime doesn't apply in the UK anymore, and that provided for reciprocal enforcement of UK judgments in the EU and the EU back into the UK. And so that came to an end in respect of any proceedings which were started after the 31st of December 2020. And so I think what we've all been expecting was that the UK would join something called the Lugano Convention, which operates on a previous version of the Brussels recast regime. Whilst not ideal, it would be a fairly attractive thing for the UK to have. And it looks like, from recent reports a couple of weeks ago, that the EU is going to block the UK's accession to the Lugano Convention. So what we're left with is the Hague Convention 2015, which the EU is a member of, and so the UK is in its own right as of the 1st of January of this year, and that provides for enforcement of judgments raised in the UK and in the EU, but in respect of contracts where there is an exclusive jurisdiction clause. So that means that you have to agree that a particular court has exclusive jurisdiction to hear that dispute. So if you are dealing with EU counterparties at the moment and you're happy to have an exclusive jurisdiction clause, then the Hague Convention may actually give you the best route going forward. Alternatively, what we saw, certainly in the context of last year, when there was still this uncertainty as to what the regime was going to be post the end of the Brexit transition period, was lots of parties actually adopting arbitration clauses so they could take advantage of something called the New York Convention 1958, which allows for the reciprocal enforcement of arbitration awards across, I think there's about 164 territories now across the world, which are members to the New York Convention. Again, what I'll do is I'll make sure that we sort of follow up with a previous presentation that we did in the follow up to this, because I'm conscious of time that we're up to 3:30. So I just want to say thank you very much for attending this afternoon. We'll follow up with the recording and the slides to this presentation, and also just a reminder about the next two installments of contract conversations in the series. But in the meantime, thank you very much for attending, and have a great afternoon. Thank you very much.